I was standing in my backyard in Aurora, Colorado, staring at the 3 rain barrels I just finished installing when I heard the clicking of heels on my driveway, and something told me my peaceful Saturday morning was about to go straight to hell. "Excuse me. Excuse me." The voice was shrill enough to make my neighbor's dog start barking. I turned around to see a woman in her mid-50s marching toward me with a clipboard clutched to her chest, like it was some kind of sacred text. Her blonde hair was cut in that aggressive bob that screamed, "I want to speak to your manager," and her lipstick was so bright it could probably be seen from space. I wiped my hands on my jeans and walked over to meet her at the gate. "Can I help you?" "I'm Patricia Whitmore, president of the Meadowbrook Estates Homeowners Association." She said it like she was announcing herself as royalty. "And I'm here to inform you that those," she pointed a manicured finger at my rain barrels, "are a direct violation of our community guidelines." I blinked at her. "Rain barrels? You're serious right now?" "Completely serious, Mr. Daniels." She flipped through the papers on her clipboard with practiced efficiency. Section 12. Subsection 4 of our HOA covenant clearly states that no external water collection systems are permitted without prior written approval from the board. "Patricia, I bought this house 6 months ago. I read through those covenants. There's nothing in there about rain barrels." I'd actually spent an entire evening going through that document with a fine-tooth comb, specifically because I'd heard horror stories about HOAs. She pursed her lips so tight they almost disappeared. "Well, it falls under the general aesthetic guidelines. Those barrels are unsightly and they detract from the uniform appearance of our neighborhood. They're blue barrels next to my garage. You can barely see them from the street." I gestured toward the front of my house. "And Colorado has laws protecting rainwater harvesting." I looked it up before I bought them. "Our HOA rules supersede state recommendations," Patricia said, her voice dripping with condescension. "That's not how laws work," I replied, trying to keep my voice level. "State law actually supersedes HOA covenants when they conflict." Her face turned an interesting shade of red. "Mr. Daniels, I'm giving you 72 hours to remove those barrels or you'll be fined $50 per day until they're gone." "Do I make myself clear, Crystal?" I said. "But I'm not removing them." Patricia's eyes narrowed. "We'll see about that." She spun on her heel and marched back down my driveway, leaving me standing there feeling like I'd just been hit by a very angry, very entitled tornado. My name is Ian Daniels, and I'd moved to Aurora 6 months earlier for a fresh start after my divorce. I work as a software engineer for a company downtown, and I'd specifically chosen this house because it had a decent-sized yard and seemed like a quiet place to rebuild my life. The HOA hadn't seemed too invasive during the buying process, just the usual rules about keeping your lawn maintained and not painting your house neon pink. I walked back to my rain barrels and ran my hand along the smooth plastic. I'd done my research on this. Colorado had actually passed House Bill 1259 back in 2016, which explicitly allowed residential property owners to collect rainwater from their roofs using 2 containers that could hold up to 55 gallons each. In 2021, they'd expanded that law even further. I had 3 50-gallon barrels, which put me well within the legal limits. I pulled out my phone and called my friend Marcus, who worked as a paralegal. He answered on the 3rd ring. "Ian, what's up, man? I need some legal advice. My HOA just told me I have to remove my rain barrels or face daily fines." Marcus let out a low whistle. "Rainwater harvesting? Dude, that's legal in Colorado, has been for years." That's what I told her, but she insisted the HOA rules supersede state law. "Yeah, no, that's not remotely correct." HOA covenants can't violate state statutes. You've got the law on your side here. I could hear him typing on his keyboard. Hold on, let me send you some information. You're going to want to document everything. Every interaction, every letter, every fine notice. And you should probably send them a formal letter citing the relevant statutes. You think it'll come to that, if she's already threatening fines? Yeah, I think it's going to get messy. These HOA board members, especially the power-hungry ones, they don't like being told they're wrong. We talked for another 15 minutes before I hung up. Marcus sent me links to the relevant Colorado statutes, and I spent the rest of the afternoon drafting a formal letter to the HOA board. I cited House Bill 1259, included quotes from the Colorado Revised Statutes Section 40-3.1, and politely but firmly stated that I would not be removing the rain barrels. Monday morning, I printed out the letter, made several copies for my records, and sent it via certified mail to the HOA board's listed address. Then I went to work, hoping that would be the end of it. I should have known better. 3 days later, I came home to find a bright orange violation notice zip tied to my mailbox post. According to the notice, I was now being fined $50 per day starting immediately, and if I didn't comply within 30 days, they would take further action, which included the possibility of placing a lien on my property. I took photos of the notice from multiple angles, then carefully removed it and added it to the growing folder I'd started for this situation. My hands were shaking slightly as I went inside. A lien on my property, over rain barrels that I had every legal right to own. That evening, I sat down and wrote another letter, this one more detailed. I included copies of the Colorado statutes, referenced several court cases where HOAs had lost similar battles, and requested that all fines be immediately rescinded. I also requested to attend the next HOA board meeting to address the issue in person. The response came faster than I expected. 2 days later, I received a letter from someone named Deborah Carmichael, the HOA's secretary. The letter was brief and unhelpful. It stated that the board had reviewed my concerns and determined that their original position stood. The fines would continue to accumulate. The next board meeting was scheduled for 3 weeks away, and I was welcome to attend during the homeowner comment period, which was limited to 3 minutes per speaker. 3 minutes. They were giving me 3 minutes to defend my legal right to collect rainwater on my own property. I called Marcus again that night. They're not backing down, they're actually doubling down on the fines. Then you need to get a lawyer, a real one, not just your paralegal buddy. He paused. Look, I can ask around my office. We don't handle HOA disputes, but I know some people who do. This is absolutely worth fighting. It's going to cost money though, right? Probably more than just paying the fines and removing the barrels. Maybe in the short term, Marcus said. But what happens next time they decide they don't like something perfectly legal you're doing? You paint your door the wrong shade of white. You plant the wrong kind of flowers. These people need to be stopped, Ian. And honestly, in cases like this where the HOA is clearly violating state law, you've got a really strong case. You might even be able to recover your legal fees. He had a point. This wasn't really about the rain barrels anymore. It was about not letting a petty tyrant with a clipboard dictate what I could and couldn't do in my own home. Marcus connected me with an attorney named Sarah Brennan, who specialized in property law and HOA disputes. I met with her the following Tuesday at her office in downtown Denver. She was in her early 40s, sharp-eyed and professional, and she didn't waste time with small talk. "Tell me everything from the beginning," she said, pulling out a legal pad. I walked her through the entire situation, from Patricia's first visit to the accumulating fines to the letters I'd sent. I showed her all my documentation, the photos, the violation notices, the certified mail receipts. Sarah reviewed everything carefully, occasionally making notes. When I finished, she leaned back in her chair and smiled. It wasn't a friendly smile. It was the smile of someone who'd just been handed an easy win. "This is one of the most clear-cut cases I've seen in a while," she said. "Your HOA is flagrantly violating Colorado state law. House Bill 1259 and the subsequent amendments are crystal clear. You have the right to harvest rainwater. Their covenants cannot override that. So what do? First, we send them a letter from my office. That usually gets their attention because it shows you're serious. We cite the relevant laws, demand they rescind all fines, and give them a deadline to respond. If they don't comply, we file a lawsuit. Given how clear the law is here, I'd expect this to settle pretty quickly once they realize they're going to lose. And if it doesn't settle, then we go to court and we win. And we ask the court to award you your attorney's fees, compensation for the stress and time you've spent dealing with this, and possibly even punitive damages if we can show the HOA acted in bad faith." She tapped her pen on the legal pad. "HOAs have a lot of power, but they're not above the law. Too many of them forget that." We discussed her fees, which honestly made me wince, but I decided it was worth it. I wasn't going to let Patricia Whitmore and her board of suburban dictators push me around. Sarah drafted a letter that same day. It was 5 pages of legal language that basically boiled down to, "You're wrong. You're breaking the law. Fix this immediately, or we'll see you in court." She sent it via certified mail and email to ensure they received it. The next HOA board meeting was scheduled for the following Thursday. I marked it on my calendar and prepared what I wanted to say, though I knew 3 minutes wouldn't be nearly enough time to cover everything. In the meantime, the fines kept accumulating. According to the HOA's accounting, I now owed them over $600. I didn't pay a cent. Sarah had advised me to let the fines pile up, as it would only strengthen our case when we went after them for damages. Thursday evening arrived, and I drove to the community center where the HOA meetings were held. It was a bland, beige building with fluorescent lighting that flickered slightly, giving the whole place an uncomfortable, institutional feeling. I arrived 15 minutes early and found a seat in the back row of folding chairs that had been set up in the main room. Other homeowners trickled in slowly. By the time 7 o'clock rolled around, there were maybe 20 people in the room. Patricia sat at a table at the front with 4 other board members. I recognized Deborah Carmichael from the photo on the HOA website. The other 3 were men I'd seen around the neighborhood but had never spoken to. Patricia called the meeting to order with a sharp rap of a gavel. They went through the usual boring agenda items first. Approval of last month's minutes, treasurer's report, discussion of landscaping bids for the common areas. I sat through it all, watching the clock and waiting for the homeowner comment period. Finally, after nearly 45 minutes, Patricia announced that they would now hear from homeowners. "Please remember that each speaker is limited to 3 minutes," she said, looking directly at me. "We ask that you keep your comments respectful and relevant to HOA matters." I stood up and walked to the front of the room. Several heads turned to watch me. I pulled out my notes, though I'd practically memorized what I wanted to say. "My name is Ian Daniels. I live at 1247 Meadowbrook Drive. 3 weeks ago, I was informed that I'm being fined $50 per day because I installed rain barrels in my backyard. I was told these barrels violate HOA covenants." I looked directly at Patricia. "However, Colorado state law explicitly permits rainwater harvesting. House Bill 1259, passed in 2016 and expanded in 2021, gives homeowners the right to collect precipitation from their roofs, using up to 2 containers of up to 55 gallons each. That law was further amended to allow even more collection under certain circumstances. Patricia started to interrupt, but I kept talking. HOA covenants cannot override state law. That's a fundamental principle of how laws work in this country. I've sent multiple letters to the board citing the relevant statutes, and I've received no substantive response except continued threats of fines and liens. I'm now being told I owe over $600 for exercising a right explicitly protected by state law. Your time is almost up, Mr. Daniels, Patricia said coldly. I've retained legal counsel, I continued, and I'm prepared to take this matter to court if necessary. I'm asking the board to do the right thing. Rescind these illegal fines. Acknowledge that rainwater harvesting is permitted under state law and stop harassing homeowners who are doing nothing wrong. Time, Patricia announced, clicking a timer on her phone. I returned to my seat, my heart pounding. Several other homeowners were whispering to each other, and I caught a few sympathetic looks. Patricia cleared her throat. The board will take your comments under advisement. However, I want to remind everyone that when you purchased your homes in Meadowbrook Estates, you agreed to abide by our community covenants. Those covenants exist to maintain property values and ensure our neighborhood remains attractive and uniform. We cannot simply ignore our own rules because someone decides they don't like them. It's not about liking them, I said, unable to stop myself even though my time was up. It's about them being illegal. Mr. Daniels, you've had your time to speak, Patricia snapped. If you continue to interrupt, I'll have you removed from this meeting. An older man in the front row raised his hand. I'd like to hear more about this. Are you saying the HOA can't enforce rules that violate state law? We're not violating any laws, Deborah Carmichael interjected. Our covenants are legitimate and enforceable contracts that all homeowners agreed to. But if state law says he can have rain barrels, how can you fine him for it? Another woman asked. Patricia's face was getting red again. This is not a debate. The board has made its decision. Next topic on the agenda. Actually, I think we should table this and get a legal opinion, one of the male board members said. He was younger than the others, maybe in his 30s, with glasses and a nervous demeanor. If there's a question about whether we're violating state law, we should probably consult with our HOA attorney before we continue with the fines. There's no question, Robert, Patricia said through gritted teeth. The covenants are clear. But he's saying state law is also clear, and that it's on his side, Robert persisted. Shouldn't we at least verify that before we risk a lawsuit? I could have kissed Robert right then. Finally, someone on the board with a functioning brain. We'll discuss this in executive session, Patricia said firmly. This meeting is adjourned. She banged the gavel before anyone else could speak. I left the community center feeling frustrated but slightly hopeful. At least one board member seemed willing to question Patricia's dictatorial approach. I called Sarah on the drive home and filled her in on what had happened. Good, she said. The fact that they're even considering consulting their attorney means they're worried. Keep documenting everything. Record the dates and times of these meetings. Save any emails or letters you receive. We're building a very strong case here. The following week, I received an email from Robert Chen, the board member who'd spoken up at the meeting. He apologized for reaching out directly, but said he wanted to understand the legal situation better. I forwarded him all the information I'd compiled about Colorado rainwater harvesting laws, along with several articles about HOAs losing similar disputes in other states. Robert responded the next day. thanking me and admitting that he hadn't been aware of the state laws when he joined the board 6 months earlier. He said he was going to push for the board to consult with their attorney and reconsider their position. 2 weeks passed with no official communication from the HOA, though the fines theoretically continued to accumulate. I was now supposedly over $1,200 in debt to these people. Sarah advised me to be patient, suggesting that silence might mean they were actually consulting with legal counsel and realizing they were in trouble. Then everything exploded. I came home from work on a Tuesday to find a notice on my door. Not a violation notice this time, but something much worse. It was a formal notice of intent to place a lien on my property for failure to pay outstanding fines. The notice gave me 14 days to pay the full amount, which they now calculated at $1,400, or they would proceed with the lien. I immediately called Sarah. "They're threatening to put a lien on my house." "They can't do that," she said flatly. "Well, they can try, but it won't hold up. This is actually perfect for us because now they're not just enforcing an illegal rule, they're taking concrete action to harm you financially based on that illegal rule. We're filing suit tomorrow." "Are you sure?" "Ian, I've been doing this for 15 years. Trust me. We're going to bury them." She paused. "But I want you to be prepared. This is going to get ugly before it gets better. They're going to fight back, probably try to make your life difficult in other ways. Document absolutely everything from this point forward." True to her word, Sarah filed a lawsuit the next day in Arapahoe County District Court. The suit named the Meadowbrook Estates Homeowners Association as the defendant and sought an injunction against the fines and threatened lien, a declaratory judgment confirming my right to harvest rainwater under Colorado law, compensatory damages for my legal fees and time, and punitive damages for the HOA's bad faith enforcement of an illegal rule. The lawsuit made the local news. A reporter from a Denver TV station contacted me for an interview, and I spent 30 minutes on camera explaining the situation. The story aired that evening, and suddenly, I was getting emails and calls from neighbors I'd never spoken to before. Some were supportive, sharing their own HOA horror stories. Others were critical, saying I was causing trouble over something trivial and that I should just follow the rules. Patricia Whitmore went on the defensive immediately. She sent an email to all Meadowbrook Estates residents claiming that I was spreading misinformation and that the HOA was well within its rights to enforce community standards. The email painted me as a troublemaker who wanted to turn the neighborhood into an eyesore with industrial water tanks. My 3 rain barrels were apparently industrial water tanks now. Sarah filed for a preliminary injunction to stop the threatened lien while the case proceeded through the courts. The hearing was scheduled for 3 weeks out. In the meantime, the local media attention continued to grow. A newspaper columnist wrote a piece about HOA overreach, using my case as a prime example. The comments section became a battlefield between people who thought HOAs were necessary for maintaining property values and people who saw them as petty tyrannies. The preliminary injunction hearing arrived on a cold morning in early November. I sat next to Sarah at a table in the courtroom, trying not to fidget with my tie. Across the aisle, the HOA was represented by a lawyer named Gregory Harrison, a stern-looking man in his 60s who'd probably been handling HOA cases since before I was born. Judge Martha Reynolds presided. She was a no-nonsense woman who'd been on the bench for over 20 years, and she'd clearly read all the briefs because she started the hearing by cutting straight to the heart of the matter. "Mr. Harrison, I've reviewed the Colorado statutes regarding rainwater harvesting. They seem quite clear. How does your client justify fining Mr. Daniels for exercising a right explicitly protected by state law? Harrison stood and adjusted his glasses. Your Honor, the HOA covenants are contractual agreements that all homeowners enter into voluntarily when they purchase property in Meadowbrook Estates. Mr. Daniels agreed to abide by these covenants, which include aesthetic guidelines for external installations. But the covenants don't specifically mention rain barrels, do they? The judge asked. They fall under the general provisions regarding external modifications and additions, Harrison argued. The HOA board has discretion to interpret and enforce these provisions to maintain community standards. Judge Reynolds looked skeptical. But again, state law explicitly permits what Mr. Daniels is doing. Can HOA covenants override state statutes? We're not overriding state law, Your Honor. We're enforcing private contractual agreements that govern aesthetic matters within the community. Except you're fining him for something the state says he's allowed to do. The judge turned to Sarah. Miss Brennan, your position. Sarah stood smoothly. Your Honor, this is a straightforward case of HOA overreach. Colorado law is unambiguous. Residential property owners have the right to harvest rainwater using rooftop precipitation collection systems. The HOA cannot fine my client for exercising this statutory right, regardless of what their covenants say. Private agreements cannot negate state law. Furthermore, the threatened lien represents immediate and irreparable harm to my client. We ask that the court issue a preliminary injunction blocking any attempt to place a lien on Mr. Daniels' property and ordering the HOA to cease imposing fines related to his rainwater harvesting system. The judge asked several more questions, diving into the specific language of both the HOA covenants and the state statutes. Harrison tried to argue that the rain barrels violated aesthetic standards, but the judge wasn't buying it. I've seen the photographs submitted in evidence, Judge Reynolds said dryly. These are standard blue rain barrels positioned next to a garage. They're barely visible from the street. I'm struggling to see how they're such an aesthetic catastrophe that they justify daily fines and threats of liens. Your Honor, it's about the principle, Harrison said. If we allow one homeowner to ignore the covenants, others will follow, and the community standards will erode. The principle here is that HOAs don't get to override state law, the judge replied sharply. I'm granting the preliminary injunction. The Meadowbrook Estates HOA is hereby ordered to cease all fines against Mr. Daniels related to his rainwater collection system, and is prohibited from placing any lien on his property related to this matter. This injunction will remain in effect pending resolution of the underlying lawsuit. I felt Sarah grip my arm in victory. I tried not to grin too widely, but it was hard. The judge was clearly on our side. We left the courtroom and stood on the steps outside, where Sarah gave me a high five that probably wasn't very professional but felt fantastic. That was a clear win, she said. The judge basically told them they're wrong about everything. Now we wait and see if they want to keep fighting or if they'll settle. You think they'll settle? They should. Any reasonable attorney would advise them to settle at this point, but HOA boards aren't always reasonable. They're often more concerned with not looking weak than with making smart legal decisions. She was right to be cautious. The HOA didn't settle. Instead, they doubled down. A week after the injunction hearing, I received another letter from the HOA. This time, they were citing me for a different violation. According to the letter, my lawn was 1/4 inch longer than the maximum length permitted under the covenants, and I was being fined $25. I measured my lawn myself. It was perfectly fine. I called Sarah. They're retaliating, she said immediately. This is actually great for us. Document everything. Measure your lawn, take photos with timestamps, get it professionally measured if you need to. Every retaliatory action they take just adds to our case. Over the next month, the HOA sent me 4 more violation notices. My mailbox was apparently the wrong shade of black. My garbage cans were visible from the street for more than the permitted time window. My porch light was too bright. My doormat was the wrong size. Every single violation was either completely fabricated or so petty it was laughable. And every single one came with a fine. Sarah amended our lawsuit to include claims of harassment and retaliation. She also filed a motion for sanctions against the HOA for bad faith conduct. The judge granted a hearing on the sanctions motion. At this point, the case was attracting even more media attention. A national news outlet picked up the story, and suddenly, I was getting interview requests from across the country. I did a few, always careful to stick to the facts and not say anything that could hurt our case. The HOA was getting attention too, but not the kind they wanted. Local residents started a Facebook group called Meadowbrook Estates, HOA Horror Stories, and it quickly filled with hundreds of posts from current and former residents detailing similar experiences with overzealous enforcement and petty retaliation. Several people reached out to me directly, offering to testify about their own experiences if it would help my case. Patricia Whitmore became increasingly hostile. She started showing up at my house unannounced, clipboard in hand, photographing my property from the sidewalk and looking for violations. I installed a doorbell camera after she rang my bell at 6 in the morning one Saturday to inform me that my recycling bin was 2 inches over the property line. The sanctions hearing was scheduled for mid-December. Sarah was confident we'd win, but she warned me that even if we got sanctions, it might not stop the harassment. The problem with people like Patricia, she explained over coffee one afternoon, is that they define themselves by their power within the HOA. Being board president is probably the most important thing in her life. When you challenge that, when you make her look foolish, she takes it personally. This isn't about rain barrels anymore. It's about her ego. The hearing arrived on a snowy Thursday morning. The courtroom was more crowded this time. Several reporters were present, along with a handful of my neighbors who'd come to watch. Judge Reynolds looked even less amused than she had at the previous hearing. "Mr. Harrison, I've reviewed the violation notices your client has issued to Mr. Daniels since our last hearing. Would you care to explain why Mr. Daniels is suddenly racking up violations at an unprecedented rate?" Harrison looked uncomfortable. "Your Honor, the HOA has a duty to enforce all covenant violations uniformly across the community. These are legitimate violations that required attention." "Is that so?" The judge pulled out a document. "So Mr. Daniels' mailbox being the wrong shade of black is a legitimate violation. Can you show me where in the covenants it specifies the exact Pantone color required for mailboxes?" "The covenants require that all external fixtures maintain a uniform appearance," Harrison said weakly. "And yet, I have photographs here submitted by Mr. Daniels showing at least 15 other mailboxes in the neighborhood that are various shades of black, none of which appear to have been cited for violations." Judge Reynolds leaned forward. "Mr. Harrison, your client is engaging in targeted harassment. It's obvious, it's petty, and it's going to stop. Your Honor, I'm imposing sanctions of $5,000 against the Meadowbrook Estates HOA for bad faith conduct and abusive process. Additionally, I'm issuing an order that the HOA may not issue any violation notices to Mr. Daniels unless they are first reviewed and approved by this court." Any violation notice must be accompanied by evidence that identical violations by other homeowners are being enforced with equal vigor. The courtroom buzzed with whispered conversations. I saw Patricia Whitmore in the gallery, her face bright red, looking like she wanted to explode. Judge Reynolds wasn't finished. Furthermore, I'm moving up the trial date for the underlying lawsuit. We're going to resolve this matter quickly, because it's clear that allowing it to drag out will only result in continued harassment. Trial is set for January 15th. Gentlemen, Miss Brennan, I suggest you use the intervening time to seriously consider settlement, because I'm not inclined to look favorably on parties who waste this court's time with frivolous disputes. We left the courthouse to find a cluster of reporters waiting. Sarah gave a brief statement about being pleased with the judge's decision and hoping the HOA would now see reason. I declined to comment beyond saying I was happy to have the court's protection. That night, my phone rang. It was Robert Chen, the board member who'd questioned Patricia at the meeting months ago. "Ian, I wanted to give you a heads up. There's a special board meeting tomorrow night. Some of us are calling for Patricia's resignation. Seriously, she's out of control. The $5,000 sanction is coming out of HOA funds, which means all the homeowners are paying for her vendetta against you. Plus, with all the media attention, property values are actually starting to drop. People don't want to buy into a neighborhood with an insane HOA. Several board members have had enough. Is she going to resign?" Robert laughed bitterly. "Not willingly, but we have enough votes to remove her. Just wanted you to know. And Ian, I'm sorry. I should have stood up to her from the beginning. You stood up when it mattered. Thanks for letting me know." The next evening, I didn't attend the special board meeting, but Robert texted me updates throughout. The meeting apparently got heated, with Patricia screaming at the other board members and accusing them of betrayal. In the end, 4 of the 5 board members voted to remove her as president. She was still on the board, but she no longer had executive authority. Robert was elected as the new president. His first official act was to send me a letter apologizing for the HOA's conduct and proposing a settlement of the lawsuit. The HOA would formally acknowledge my right to maintain rain barrels under Colorado law, rescind all fines related to the rain barrels and the retaliatory violations, pay my attorney's fees, and issue a formal apology. In exchange, I would agree to drop the lawsuit. Sarah and I discussed it at length. "It's a good offer," she said. "Better than I expected, honestly, but the decision is yours. We can still go to trial and probably win even more." I thought about it. The HOA had already paid $5,000 in sanctions. They were offering to cover my attorney's fees, which were substantial, and most importantly, they were admitting I was right. Let's take it, I decided. I'm tired of fighting. I just want to collect rainwater in peace. Sarah negotiated a few more details, including a provision that the HOA would revise their covenants to explicitly permit rainwater harvesting systems that complied with state law. We signed the settlement agreement in early January. The local news covered the settlement, framing it as a victory for homeowner rights and a cautionary tale about HOA overreach. I did one final interview, emphasizing that I'd never wanted to be in this position, but felt it was important to stand up for my rights. Life slowly returned to normal after that. My rain barrels sat peacefully next to my garage, collecting precipitation just as they were meant to. I used the water for my garden, which thrived that spring. Patricia Whitmore resigned from the HOA board entirely 2 months later. I heard through the neighborhood grapevine that she'd put her house up for sale and was moving to a different community. I felt a small pang of something, not quite sympathy, but maybe understanding. She'd built her identity around being HOA president, and losing that had clearly devastated her. Robert turned out to be a reasonable and competent HOA president. He instituted new policies requiring board votes for any fines over a nominal amount, and created a dispute resolution process for homeowners who disagreed with violations. The neighborhood Facebook group, which had started as a complaint forum, gradually transformed into a more positive community space. I stayed in my house, tended my garden with my legally harvested rainwater, and tried to be a good neighbor. The whole experience had taught me some important lessons about standing up for yourself and not backing down when you know you're right, even when it feels easier to just give in. But it had also taught me something else. Sometimes the people who seem the most powerful, like Patricia with her clipboard and her threats, are actually the most fragile. Their power is an illusion, sustained only as long as people are too tired or too scared to challenge it. The moment someone calls their bluff, the whole facade crumbles. On a warm evening in late May, I was in my backyard, watering my tomato plants with water from my rain barrels when my doorbell rang. I walked around front to find an older couple standing on my porch. "Hi, I'm sorry to bother you," the woman said. "We're looking at houses in the neighborhood, and our real estate agent mentioned you had some trouble with the HOA. "That's putting it mildly," I said with a smile. "But it's been resolved. New board, much more reasonable." "That's good to hear. We're moving from Texas, and we had some real nightmare HOA experiences there. I actually read about your case in the news. That's why I wanted to talk to you. My husband wants to install solar panels, and I was worried the HOA might give us trouble." "Colorado has pretty strong laws protecting solar installations too," I told her. "And the new board president is much more aware of state laws now. I think you'll be fine." We chatted for a few more minutes before they left to continue their house hunting. As I watched them walk down the street, I realized that the whole ordeal had actually accomplished something beyond just protecting my right to collect rainwater. It had changed the HOA itself, made it more accountable and more aware of its limitations. The story spread through the community too. Other homeowners in other HOAs heard about the case and started questioning their own board's authority. I got emails from people across Colorado thanking me for fighting back. A few even used my case as precedent in their own disputes. Sarah called me a few months after the settlement to tell me that the Meadowbrook Estates case had been cited in another lawsuit, this one involving solar panels in Jefferson County. "Your rain barrels are now legal precedent," she said with amusement. "How does it feel to be a landmark case?" "Surreal," I admitted. "I just wanted to water my garden." "Well, you've done a lot more than that. You've reminded people that HOAs aren't all powerful and that state law actually means something." That summer, I expanded my garden significantly, adding raised beds for vegetables and creating a small greenhouse. Everything was watered with rainwater from my barrels, which I emptied and refilled multiple times as Colorado's afternoon thunderstorms rolled through. My neighbor to the left, an elderly man named Frank who I'd barely spoken to before all this started, came over one day to ask about my rain barrel setup. "I've been thinking about getting some myself," he said. "For my roses. Would you mind showing me how you've got yours configured?" I spent an hour walking him through the system, explaining how the downspouts directed water into the barrels and how I'd installed simple spigots at the bottom for easy access. 2 weeks later, Frank had his own rain barrel setup installed. Then the family across the street got some. Then another neighbor. By the end of summer, there were at least a dozen houses in Meadowbrook Estates with rain barrels visible in their yards. It became a bit of a trend, a visible symbol of the neighborhood's shift away from Patricia's authoritarian approach to a more relaxed, reasonable attitude. The HOA even put together an informational packet about rainwater harvesting, including tips for installation and maintenance, along with information about Colorado water laws. Robert sent me a draft to review before they distributed it to all homeowners. I was happy to help. In August, the neighborhood held its annual summer barbecue at the community center. I'd skipped it the previous year, still too new to the neighborhood to feel comfortable at large social gatherings. This year, I decided to go. The turnout was impressive, with dozens of families gathered around picnic tables and a large grill setup. Kids ran around playing tag while adults chatted and ate. Robert spotted me and waved me over to where several board members were standing. "Ian, glad you could make it. Have you met everyone?" "This is Jennifer, our new treasurer, and Thomas, who handles landscape oversight." We shook hands and made small talk. Jennifer thanked me for pushing back against Patricia's overreach. Honestly, she was making decisions without consulting the rest of us half the time. "Your lawsuit kind of forced us all to pay attention to what was actually happening." "I didn't mean to cause such a mess," I said. "Are you kidding? You did us a favor." Thomas took a sip of his beer. "Property values dipped a little during all the negative publicity, but they've already bounced back. Turns out people actually want to live in a neighborhood where the HOA isn't completely insane." As the evening went on, several other neighbors approached me to share their own stories or simply to say they were glad things had worked out. A few apologized for not speaking up sooner. One woman, Barbara Costa, told me that Patricia had threatened to fine her years ago over a decorative bench in her front yard, and she'd removed it rather than fight. "I wish I'd had your courage," she said. "It wasn't really courage," I told her honestly. "It was mostly just stubbornness and a good lawyer." "Well, whatever it was, thank you." As the sun set and the party wound down, I found myself sitting at a picnic table with Robert, watching the kids chase fireflies in the gathering dusk. "You know what's funny?" Robert said. "Patricia actually called me last week." "Really? What did she want?" She said she was sorry, said she'd let the power go to her head and lost perspective. He shrugged. "I don't know if she really meant it or if she's just trying to salvage her reputation before she moves, but either way, it was something." "That must have been hard for her to do," I said. "Probably. She asked if I thought she should reach out to you." "I told her that was up to her, but I didn't think you'd want to hear from her." "You're probably right." I paused. "But I hope she's okay. I mean, I'm not saying what she did was acceptable, but I can't imagine it's easy to have your entire identity wrapped up in something and then lose it." "You're more generous than I'd be," Robert said. "She made your life hell for months." "Yeah, she did. But I won and she lost everything. I can afford to be generous now." We sat in comfortable silence for a while, watching the neighborhood kids play. This was what I'd wanted when I moved to Aurora, this sense of community and belonging. It had taken a legal battle to get here, but it was worth it. September came, and with it the start of fall. My garden began to wind down for the season, but I was already planning next year's layout, excited to expand even further. The rain barrels had proven their worth over the summer, providing hundreds of gallons of free water and reducing my utility bills noticeably. I got a message on LinkedIn from a journalist who was writing a book about HOA disputes and wanted to include my story. I agreed to be interviewed, spending several hours on phone calls talking through everything that had happened. The journalist, a woman named Emily who'd covered real estate law for decades, told me my case was particularly interesting because it had such a clear resolution. "A lot of HOA disputes end up in this murky middle ground where nobody really wins," she explained. "Your case is unusual because you got a clear victory, changed the HOA's behavior and set precedent for other homeowners. Plus, you had the advantage of being unambiguously right from a legal standpoint. It didn't feel like an advantage at the time, I said with a laugh. I'm sure it didn't. But cases like yours are really important for pushing back against HOA overreach. These organizations have gotten way too powerful in a lot of communities, and they need to be reminded that they're still subject to state and federal law. The conversation made me realize that what had started as a personal dispute over rain barrels had become part of a much larger conversation about property rights, community governance, and the balance between collective interests and individual freedoms. That October, I was invited to speak at a community meeting in Centennial, another Denver suburb, where homeowners were dealing with their own overbearing HOA. I shared my story, offered advice about documentation and legal strategy, and encouraged them to stand firm if they believed they were in the right. Several people came up afterward to thank me and ask follow-up questions. One man, probably in his 60s, shook my hand and said, "You've inspired a lot of people. My HOA tried to tell me I couldn't fly the American flag in my yard. I was about to give in, but after hearing about your case, I decided to fight back. Turns out there's federal law protecting flag displays." They backed down immediately once I cited it. Stories like that made the whole ordeal feel worthwhile. I hadn't just fought for my rain barrels. I'd somehow become a symbol of resistance against petty tyranny, which was both flattering and slightly absurd. November brought the anniversary of my first encounter with Patricia Whitmore. A year had passed since that Saturday morning when she'd marched into my backyard with her clipboard. So much had changed since then. The neighborhood was different, I was different, and even the HOA itself had fundamentally transformed. I was working from home one afternoon when the doorbell rang. I opened it to find a delivery person with a large package. After signing for it, I brought it inside and opened it carefully. Inside was a beautiful handmade wooden plaque with an engraved message. In appreciation for standing up for homeowner rights in Meadowbrook Estates, with gratitude from your neighbors. It was signed by dozens of people from the neighborhood. I hung it on the wall in my home office, where I could see it while I worked. Winter arrived, bringing snow and cold temperatures. My rain barrels sat dormant, waiting for spring. I used the quiet months to research and plan, looking into ways to expand my water conservation efforts. I started designing a more sophisticated system that would filter and store even more rainwater, potentially enough to handle all my outdoor watering needs for the entire year. In January, Robert called with unexpected news. There's a developer interested in building a new subdivision on the east side of Aurora. They've asked me to consult on setting up their HOA covenants. They specifically want to avoid the kind of problems we had. That's great. Are you going to do it? I'm thinking about it. But I wanted to ask if you'd be willing to review their proposed covenants before they finalize them. Make sure there's nothing in there that conflicts with state law or gives too much power to the board. Sure, I'd be happy to help. Over the next few weeks, I reviewed the proposed covenants for the new subdivision. They were remarkably reasonable, with clear provisions protecting homeowners' rights to install solar panels, harvest rainwater, and make other environmentally friendly modifications. There were still rules about maintaining property and avoiding genuine nuisances, but they were balanced and included robust appeal processes. This is how HOAs should work, I told Robert after finishing my review. Protecting genuine community interests without micromanaging people's lives. That's the goal. I think your case really opened a lot of eyes about what happens when HOAs go too far. February arrived, bringing me to the present day. As I sit here writing this, exactly 15 months after Patricia Whitmore first appeared in my backyard, I can look out my window at those 3 blue rain barrels and feel a sense of satisfaction that goes beyond just winning a legal battle. I fought back against arbitrary authority and won. I stood up for my rights even when it was expensive and stressful and uncertain. And in doing so, I helped change not just my own HOA, but contributed to a broader conversation about how these organizations should operate. The rain barrels still sit next to my garage, collecting water whenever it rains. They're more than just water conservation devices now. They're a reminder that sometimes the most important thing you can do is refuse to back down when you know you're right, even if it's just about something as simple as collecting rainwater. My phone buzzes with a text from Sarah. Just heard from Harrison. Patricia Whitmore's house sold. She's officially moved out of Meadowbrook Estates. I text back a simple thumbs-up emoji. I don't feel vindictive about her leaving. If anything, I hope she finds a place where she can be happy without needing to control everyone around her. Spring is coming soon, and with it, another growing season. My rain barrels will fill with fresh water, my garden will flourish, and life will continue in this quiet suburban neighborhood where I fought and won a battle that never should have been necessary in the first place. But I'm glad I fought it. Not just for me, but for every homeowner who's been bullied by an overzealous HOA board. For every person who's been told they can't do something they have every legal right to do. And for the principle that private organizations don't get to override state law just because they feel like it. The doorbell rings again, pulling me from my thoughts. It's Frank from next door, holding a shopping bag. "Got something for you," he says with a grin. He pulls out a bottle of wine. "My roses had the best year ever thanks to that rain barrel you helped me set up. Figured I owed you a thank you." We sit on my porch for a while, drinking wine and talking about gardening plans for the upcoming season. This is what neighborhood life should be like, I think. Neighbors helping each other, sharing successes, building community through genuine connection rather than enforced conformity. As Frank leaves and I head back inside, I pass the plaque on my office wall. I run my fingers over the engraved words, thinking about the long journey from that first confrontation to this moment of peace. Tomorrow, I'll probably go back to my normal routine, working my software engineering job and living my quiet life. But I'll always have this story, this reminder that one person standing up for what's right can make a real difference, even if it's just about 3 blue rain barrels in a suburban backyard. The rain barrels remain, silent witnesses to a battle won and a principle defended. And when the spring rains come, they'll do exactly what they're designed to do, collecting water from the sky to nourish the earth below, legal and undisturbed, just as Colorado law says they should be.